Hey, it's Richard of Matthews Wealth Management. I'm joined today by James Anderson of Anderson Law Firm. So we're going to be talking a little bit about some estate planning. I've worked with James for a few years now, working with clients on estate planning. One of the things that separates him specifically is that's all he does. He's not going to get involved in trying to start your business and doing, suing people when you get disabled or the jack of all trades attorneys. He is a very, very specialized estate attorney. And we're going to be talking today about one of those nuances that I think a lot of clients will appreciate, where we're not just talking about how to do your beneficiary designations and avoid probate and have a will and all the 101 stuff. We're going to go a little bit higher level. So James, if you want to talk a little bit about yourself, how long you've been in business here in Fountain Inn, and then we'll dive into some estate planning.
Well, I came out of law school in '06, and the economy was terrible. So I hung my shingle from the get-go, as there were no jobs for young attorneys back then. So kind of matriculated through the School of Hard Knocks there, but been practicing here in South Carolina for about 12 and a half years. We've consolidated our location here in downtown Fountain Inn, and we do focus on, as Richard mentioned, we focus on estate planning primarily. That's really what I do all day, every day, and that's what I enjoy doing.
Very good. So earlier this year, we've talked with some clients about the Secure Act specifically that came out, and everybody's forgotten it in the world of COVID, that there was some major legislation that was effective in January of 2020 to kind of get us rolling in this great year. And one of the major things that it did was it shrunk the time horizon of RMDs on inherited IRAs. What does that mean? Basically, it used to be that an IRA could be left to a child, for instance, and they could start taking minimum distributions at that age for the rest of their life, paying the taxes on it, etc. But it wasn't a major issue until this year, where they shrunk that time frame to 10 years. So they have 10 years to take out all of that money, recognize all of that income, pay all of those taxes, as opposed to spreading it out over the rest of their life. So that's kind of where we're going to start today, is that in itself is a problem. So what is it that you're seeing people do to try to prepare for that, or a right way to maintain that IRA balance?
So I think the real issue is, for a lot of people, they've worked all their lives, they've wisely stewarded their money and set money aside in qualified retirement plans. We see so many people come through the office who the bulk of their wealth is in qualified retirement plans. That is the financial legacy that they wish to leave to their children. And they know that that type of asset passes by beneficiary designation. They think to themselves, okay, well, I got my spouse named as a primary beneficiary. I die, it's going to go straight to my spouse. No big deal. If we're both gone, I got my kids named as beneficiaries. It's going to go straight to them. Easy peasy. But the insidious thing, though, is when you rely just on beneficiary designations, a naked beneficiary designation like that is nothing but an outright gift to that beneficiary. And at first glance, people say, well, isn't that the way it's done? I mean, when my folks died, that's how I got their stuff, and I figure that's how my kids are going to get my stuff, and isn't that just the way it's done? Well, no. I mean, yeah, that's the way most people do it, but like a lot of things in life, just because most people do it a certain way is not the best way to do it. You say, well, what do you mean? Well, when you rely just on that beneficiary designation, that's the equivalent of you stroking a large 6 or even 7-figure check, from the grave to somebody else. What was once yours is now theirs. It's tucked into their person. It's part of their estate. It's in their name. Right? And again, what's the big deal with that? Well, think about it for a minute. You leave a large inherited IRA or even a life insurance policy. I don't care, anything. But you leave a large inherited IRA to an adult child. Let's say that child is married. They get their inheritance, and at some point down the road, there's trouble in paradise. There's a divorce. Well, it does not take much to for one spouse to commingle their separate inheritance with the other spouse.
Okay.
You know, they sneeze on it, they look at it the wrong way, it's commingled, all right? And you're probably going to lose half of it in a divorce.
Interesting. So not only is it the taxation piece of it that you want to make sure you're, because I remember at Ameriprise, which is where I started, and then ING, like just the typical training that they teach brokers, that they teach people in the financial business is spouse first, and then if you want to be lazy about it, you can say per stirpes, and that just sends it down to the kids, and it's minimizing how long the application takes to fill out. So it's pretty much the default methodology to say spouse, then kids. But what you're saying is not necessarily just getting it to them, but what happens down the road in the kid's life may make you want to think twice.
Yeah. So we mentioned the risk of divorce, which is statistically the biggest drain on intrafamily wealth transfer, because marriages are a flip of the coin statistically. But folks can get sued out of that. They can get sick if they if say you got a child who later in life develops a long-term care issue. All that money's going to have to be spent down before they'd ever have to qualify for Medicaid, right? Yeah. So bottom line is, it's a big bad world out there that tends to be rough on inheritances. The average inheritance lasts something like 19 months. Maybe we need to be worried about protecting that inheritor from his or herself. So I'm just going to the solution. If you're gonna plan in style, is you do not strike big checks from the grave to people. You just don't do it. You leave behind trusts for people, irrevocable asset protection trusts for them. I like to call them fortified piggy banks. I like the imagery. I think it's apt.
Sure.
But here's the thing. Mechanically, when you leave someone their inheritance in trust, it's there for them, but it's not theirs.
Gotcha.
It's still yours from the grave in a weird kind of way, and from the grave, you're still the puppet master, and you have this legal infrastructure that is going to govern how your stuff is managed and doled out for the benefit of the people that you're looking to take care of. Sure. For generations.
So if I'm playing devil's advocate, because I've heard all the arguments on the flip side of it, one of the largest arguments against trusts receiving IRA dollars would be that the trust income tax rates are significantly higher than individual tax rates. Does that apply in this situation, or is there a way around that?
It depends. It depends on how things play out, and it depends on how the trust is designed. So before I get too far ahead of myself, maybe it's obvious, but I want to make it clear. When someone leaves someone something in trust, like I said before, it's there for them, but it's not theirs. Therefore, they're not going to get divorced or sued or bankrupted or nursing homed out of it. And you get to say where that stuff goes when that beneficiary dies, all right? And so as much as you might like your in-laws, you're going to love your grandbabies more, right?
Sure.
So for most people, they're going to want to ensure that stuff can kind of cascade down the generations and stay within, moving vertically down the bloodlines. Now, if you leave someone in a gift in trust, and if the trustee of that trust pays out the income that the trust generates over the course of the year, then that income is associated with the recipient, with the beneficiary's taxable income. That just
Sure.
goes to their tax bill. Okay, the trust has to file at that point has to file a tax return, but it's going to be zero retained income, and
Gotcha.
no big deal. Sometimes though, it's not appropriate for the trustee just to pay out the income to the beneficiary.
Okay.
Maybe this person's a drug addict. Maybe they're underage. Maybe they're disabled, and this is a supplemental needs trust or a special needs trust, and it would be exceedingly unwise to pay out the income to that person because it would make them too wealthy to qualify for that aid.
Understood. Yes.
So in this case, you have income that
Is
retained or accumulated, if you will, within the trust. And yeah, so the trustee will have to report that on the taxes, and the trust will pay taxes at the tax level. But that's an acceptable risk, because we don't want to throw money at somebody that's going to use it to kill themselves. We
Sure.
don't want to throw money at somebody that's going to disqualify them from receiving Medicaid or some other aid that they rely upon.
Right.
That's an acceptable risk. But when you're dealing with healthy adult beneficiaries, Yeah, you want that thing to kind of purr along on autopilot, and the trustee just pay out income to the beneficiary over the course of the year, and so it's just going to be added to that person's taxable income.
So that,
for that
income
year.
then becomes individual income,
Right.
not trust income.
Right.
Gotcha.
And then the tricky thing is where this kind of relates to inherited IRAs is right now, post-Secure Act, as you've already said, if someone receives an IRA, whether it goes straight to them, and you know I don't think that's wise, but if it goes straight to them or if it goes into a trust, an asset protection trust for them, one way or another, you know, the taxes have to be paid over 10 years. You know, after 10 years, assuming we're dealing with an adult beneficiary who is not disabled, after 10 years, you know, then here the IRA goes away.
Right.
All right. We don't want for the trustee of a trust for a beneficiary to have to actually distribute all of the IRA to that beneficiary on a 10-year horizon, because if during that period of time, if that person's getting divorced or sued, or frankly, if they need, you know, protection from themselves, that's not good. So particularly people who have a lot of qualified retirement money sitting around, where, you know, that's going to be their big legacy gift. You don't want to give that to people outright in general, period, because it will grow legs and walk off one way or the other. You want to leave it to them in trust, but you want to make sure that that trust is set up in such a way that the IRS would consider that to be what we call an accumulation trust.
Okay.
So those RMDs that are coming out over that 10-year horizon, they can actually stay within that trust, within that fortified piggy bank.
Wow.
And be, you know, reinvested as part of the rest of the trust corpus. All right?
So that it then is not in their possession. It's still trust assets.
It's still hanging out there in the cloud.
So it kind of came out of the trust to pay the income tax, but it still stays in the trust as far as protection.
Yeah. So the trustee's going to have to pay the taxes out of the trust. You know, but that way the principal or the corpus of that inherited IRA, that stays with the trust. It becomes part of the trust principal and is going to be used to take care of the beneficiary. So in other words, like, you know, think of a tube of toothpaste. You know, we don't want to, you know, once you squeeze the toothpaste out of that, there's no putting it back in, right?
Right.
Likewise, you know, if you squeeze, you know, trust income or trust principal out of the trust to the beneficiary, you've lost all control to be able to dictate how that's being leveraged, to be able to protect it for somebody. You know, the beneficiary is not going to be able to protect what they get from you as well as you can protect it for them from the grave.
The trustee is handling the taxation part on behalf of the beneficiary without giving actual custody.
And I can just, you know, whoever's watching this at home, I can just, you know, hear the questions they're asking. Well, how do they get the money? It's up to them. Truth be told, most of my clients will say something like, you know, if I'm dealing with a beneficiary who is at least age X and they don't have problems, that they can be their own trustee. Okay, and that's fine. If that's what you want, that's fine. I mean, I've come to learn that's what most people are comfortable with. So, and you can do that. Yeah, at least, you know, speaking to the law here in South Carolina and the law in most places, you know, you can do that. Your child can be their trustee and their own beneficiary, and they can still keep it separate, which is going to afford a high degree of, you know, protection there. Not the highest degree, but a high degree of protection. But they're going to be responsible for the tax compliance and the bookkeeping. And unless they are a particularly sophisticated individual or they have the good sense to take advice and rely on it,
Sure.
You know, hire it out to people.
And that's what I've already thought as you're describing that. I would not want to be that trustee. That automatically sounds very time consuming and risky.
I'm not a fan of it. And frankly, the more time that passes, the more clients of ours that we have died, you know, and the more, you know, I try to tell people, well, you need to do this, 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 and this. They don't do this, this, that, and that.
Right.
That thought is burdensome to me. So I'm a big fan, and I know you are too, and pretty much any other financial advisor that I work with is also in agreement that we like trust companies.
Yeah.
If you get a good professional trustee involved, particularly if we're dealing with a 7-figure estate, and I don't mean a $9 million estate, I mean $1.05 million
Right.
estate, then there's enough money to cover the cost of the professional administration, the income and the growth that the investments will see over your children's lifetime are going to more than justify the costs.
Sure.
And you got somebody that knows what they're doing, who's legally accountable for it. And that way you never have to worry about your child doing something stupid. You don't have to worry about who they might be married to and how they might be manipulated. You don't have to worry about them, getting like my dad's mom and getting old and demented, and the Australian lottery calling for them.
Oh gosh.
When your elderly demented child gets that call from the Australian lottery, and they want to send $300,000 to Australia to claim their winnings, there's somebody say no.
Right.
Wasn't the case in my family, unfortunately, but we can get in front of all these things, and that. To me, that's what makes estate planning fun, and I mean that. This is, you can spend a little bit of time and a little bit of money up front, and make these investments that can reverberate for the generations. I mean, this is not talking specifically about inherited IRA planning, but just leaving things to your descendants in trusts. I mean, this is what the Kennedys did back in the day, and as their children misbehaved and drove off bridges and crashed their small aircraft off of Martha's Vineyard. I mean, those people got sued. JFK Jr.'s estate got sued, but the original liquor money is out there safe. So, not trying to compare any of y'all to the Kennedys, I know, but still, this is not avant-garde stuff. This is pretty tried and true, legal technology. But yes, if you got IRAs, you got a lot of qualified retirement plan money. Sadly, yes, all the taxes are going to have to be paid, 10 years after you're dead and gone, or at least after your surviving spouse is dead and gone. But we don't have to just vomit what we have into our children's lap and pray that stuff works out well. We don't have to do that. We can take a lot more control over what we got.
Gotcha. Well, that adds a lot of clarity to kind of the inherited IRA issues that really, in my mind, it's taxes. I think of the taxes in your view, which is, a very different view, also just as equally important, is control and protection of assets from creditors, from healthcare costs, from all sorts of potentials in life that you don't really quantify in stock market portolios and things.
Yeah,
so.
and remember, the average inheritance lasts 19 months.
It goes quick.
And I mean, the last 2 years, I've seen 2 7-figure inheritances walk off in about that time span. So that's anecdotal, but
Yeah. Well, in my mind, that's a lot of taxes. In your mind, that's money that was meant for future generations. So,
yes.
Well, thanks for joining us, James. This has been very informative for me. I know you enjoy estate planning. I enjoy estate planning as well. Hopefully the people that keep tuning into these videos will enjoy estate planning as much as they do investment planning. But we'll invite you back and try to add some more to the conversation. Thanks again.
Thanks.